Hi guys, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense here on YouTube. Today we're going to talk about something called third-party releases. I'll explain more about that in just a moment. As you are probably aware, when a company gets formed to make a product or render a service, usually the stock is initially held by the people who form the company. And then to raise additional money for expansion and that sort of thing, they take their company public. But they still retain a huge amount of stock in that company. And as their company grows, a lot of times they will spin off other companies. And somewhere along the line, one of those companies will screw up, people will get hurt, and people will sue for damages. So what we're going to talk about today is a release. A release is a fairly simple document. Basically what it says is, in exchange for something, usually some amount of money, a plaintiff or someone with a claim for money damages releases the party that did the harm, and as a result, they don't owe any more to that individual for the harm that's been caused. That's how a typical release works. But there is something called a third-party release that arises in bankruptcy. I know you're going to find this hard to believe, but basically it excuses the conduct of people who are not in bankruptcy. So we're going to take a look today at the bankruptcy of the Purdue Pharmaceuticals. And Purdue Pharmaceuticals was originally organized by a group of people called the Sackler family. And the Sackler family held most of the controlling shares of that company's stock. Well, Purdue manufactured this drug called OxyContin. It started this whole opioid epidemic and crisis. And as a result, thousands upon thousands of lawsuits have been filed, and Purdue found itself in trouble. So they went into bankruptcy. And bankruptcy is there specifically for the purpose of helping the honest debtor, the unfortunate debtor who made a mistake, right? They made a very bad product, and then they engaged in intentional misconduct by realizing that it was addictive and selling it at even greater levels, pushing the fact that it was addictive. They knew their profits would come. Very much like the tobacco companies pushed cigarettes, knowing that they were addictive. Well, all of this was being overseen by a board of directors, because a company, although it may have a chief executive officer, the chief executive officer doesn't make all of the decisions. Most of the really important decisions are made by the board of directors. And in this case, the board of directors at the Purdue Pharma was run by, or I guess consisted mostly of, Sackler family members. And they wanted, ostensibly, or it is alleged that they wanted, to continue to profit at the expense of these people who were buying their painkillers. In the bankruptcy, the allegations were not only that Purdue Pharma was at fault, but that the people on the board were at fault. And the people on the board obviously were sued in addition to the people at Purdue Pharma. So in working out a restructuring agreement, what has happened is the Sackler family has negotiated for a series of third-party releases. These third-party releases essentially say, all the money you are going to get for any harm done to you by our opioids is going to come from the trust we're setting up in bankruptcy. You can't come after us. You can't pursue us, the Sackler family. We went out of this free and clear. And several states and the Department of Justice are saying, not so fast. We don't think that's quite fair. And when you think about it, it isn't. One of the things that were guaranteed by the both the Fifth Amendment in the criminal context and the 14th Amendment in the civil context is due process of law. And early Supreme Court cases held that there should be no rights without remedies. And so when you have a right where you don't have a remedy, that's a violation of fundamental due process concerns. And what's happening here is that the courts are using something called Section 105, the same section of the Bankruptcy Code that lets them issue an injunction to stop all of these lawsuits against the third parties, and that's what they did. They stopped all of these lawsuits against the third parties, and then issue a release that binds everybody who had a claim against Purdue Pharma and against these third parties who are not even in bankruptcy. And it says all the money you'll ever get is going to come from this trust that we're setting up inside this bankruptcy. Well, essentially, the people who are suing these individuals aren't going to get a voice in that. They aren't going to get their day in court against those individuals. And it should be unconstitutional. And should be unconstitutional specifically because the right of due process and the right of access to our courts is a fundamental freedom. If a bankruptcy court can strip away the right of an individual to pursue a wrongdoer in civil court without having that individual in front of the court, then where does that court's power stop? That's a good question, isn't it? A couple of days ago, I made a video where I asked you to write to Congressman Maloney and to Congressman Nadler, and I asked them to do something about the Texas two-step. And now I'm going to ask you to do something about writing to them to do something about what I would call this third-party release problem. It has to stop. It needs to stop. Now, Congressman Maloney and Mr. Nadler, and I believe a couple of senators, Elizabeth Warren, Richard Blumenthal, have written to the Department of Justice, and they'd said, hey, you need to do something about this. You need to object to the plan. You need to step up and prevent this from happening. And I guess because the Department of Justice is busy going after people who trespassed at the Capitol, they are unable to answer that letter. I find that to be an absolute abomination. Our Department of Justice works for us, the citizens. And if it's not protecting us from the overreach of the bankruptcy courts, and frankly, the abuse of the bankruptcy system, then what good is it? Again, you can find the addresses in the House telephone book, which is available on the internet, and I would urge you to write to these individuals and ask them to do something about third-party releases. So hopefully you've learned a little something today about third-party releases and about the bankruptcy system, and maybe even a little bit about the Purdue Pharma bankruptcy. If you have any questions, please leave them in the comments down below. I'd really appreciate it if you would like this video, and if you haven't already, subscribe to our channel and click the notification bell. I try to release a video here, at least 2 every week. Sometimes I get 3 in, sometimes I don't. Next week I'm going to be in court, so I probably won't get many videos done. I appreciate you coming here and listening to what I have to say. I'd love it, again, if you haven't already, to subscribe to my channel. Thank you so much for coming. I appreciate it. Have a great day, and I'll catch you on here next time.